all received the agenda for this evening. We will be adding to that agenda at the end of the meeting the two sign applications that you received. One is for the Hudson Valley Federal Credit Union, submitted by Timely Signs. The other is for the New Hudson Medical Arts Building. And everybody's got both of those? Okay. So that is the only change that I'm aware of in terms of in addition to the agenda. I assume we'll receive the planning consultant's meeting notes. Have you had a chance to look them over? Right, we have a motion to accept them as submitted. So moved.
Second.
All those in favor? Opposed? Okay. I also assume that you've been spending a lot of time reading a lot of minutes. And the list that's before you on the agenda, the only minutes that have not been completed and made available to you are those of May 5th. Nearly completed, but could not have been completed before tonight. So you have now the minutes of regular meeting, minutes of April 7th, June 2nd, August 18, September 15, October 20, and December 15 of 2014. You have the special meetings of February 18, March 17, April 22nd, May 19, and June 25, 2014, and the regular meetings of January 5th and February 2nd, 2015. Are there any?
Sharon has a couple of questions.
I have two corrections.
Okay.
On the June 25th special meeting, under the core group, it should be Miller Road, not Mill Road. What page is that? I'm looking. It's on page 10, and on the September 15, regular minutes on page 18, under the, it should be about 9, not 9G.
Can you just do one more time, that second one?
September 15,
Yep.
page 18.
Can you tell me the correction, please?
It should be about 9, not 9G. It's in the first full paragraph of the resolution.
Got it. Anyone else? Minutes, actions. We have a motion to accept all those minutes. Offered by Sharon.
So moved. Second.
All those in favor?
Aye.
Opposed? Abstentions? Okay, correspondence and other non-agenda items and announcements. I assume you have all received notification of the stormwater management class being offered. Just to bring that to your attention to look for it if you haven't seen that. I believe it's at Cornell, is that right, Art?
I'm not positive.
I think it was.
I think it was too. And a reminder that you have, continuing education requirements as part of your appointment to the board. The other thing that I have, and unfortunately I can't give you much detail on it, I'm trying to get a little more information. The town of Rhinebeck is required annually to offer certain classes to all their employees, and it appears that they must also be offered to volunteers. Such things as hazardous waste, sexual harassment, a lot of required classes. There's a class coming up. I haven't been able to get clarification as to who needs to attend. Some of them appear to be targeted just for DPW employees. I'm working with John to try and get this straightened out. I've also raised the question of the requirement of attending and what happens if someone is working full-time and unable to attend because of work commitments. I don't have answers to that yet. I will forward to you note that I got so that you have it, and if you have questions, shoot them to me. And
So right now, the feeling is it's a requirement.
according to the email I got from John, it is a requirement. That's the way it was portrayed to me. Brennan, are you aware of this? And
I just saw it today, though, and I haven't gotten clarification.
okay, I'm seeking clarification because it is a little misleading. It'll say in parens, Highway Department, Public Works Department, and it doesn't look like we need to attend all of them. I'm not even sure whether, let me just say I'm not sure. Jesse?
I know where I work, there's volunteers. They let them take like an annual quick test, refresher, and then you're good. So
Yeah, I don't know. I have to get back to John and work that through. I'll at least give you the heads up on the initial email, and we'll take it from there. Okay. It is 6:35. You have all, I know, received an email from me in the last day or so regarding a public hearing that was scheduled for this evening. I have correspondence here from John Lyons, who is our planning board attorney, which I will read into the record, and then we'll look for some sort of recommendation. This is dated Sunday, March 1st, 2015, to me as chairwoman. From John Lyons, the project is Astor Court's application for Country Inn 1 special use permit, 189 River Road, and it is copied to Art Brode, Ron Evangelista, and the town zoning enforcement officer. Dear Ms. Moore and members of the board, before you is an application from Astor Courts LLC, the applicant for a special use permit to establish a Country Inn 1 as defined in the town of Rhinebeck zoning law. This memo addresses a threshold question, the answer to which affects whether you will begin your review of the application as presented. Question: in order to be a complete application under the zoning law, does the applicant have to submit as part of its application a completed and signed affidavit of owner from Robert Duffy because the driveway proposed to provide access to the Country Inn is located partially on Mr. Duffy's property? Answer: yes. The reasons are provided in the explanation below. Next step. In a similar recent case, that of the application of Red Wing Properties for a special use permit, the planning board tabled the application in order to maintain the status quo and granted the applicant, Red Wing, an extension of time in which to produce the affidavit of owner. In doing so, the board resolved to take no further action on the review pending production of the affidavit. The planning board may choose to extend that same extension opportunity to the applicant here, although it should be noted that the applicant is not entitled to this extension opportunity under the zoning law. Whether that opportunity is extended or not, ultimately, if the applicant here is unable to produce the affidavit, then that fact will be a basis for a rejection of the application on the ground that it is incomplete. Explanation, Part 1, Facts. The applicant proposed the establishment of a Country Inn 1, as defined in the town of Rhinebeck zoning law, in the structure commonly known as Astor Courts. The application proposes that access to the proposed Country Inn from River Road shall be gained by ingress and egress over a driveway which is shared between the applicant and the applicant's adjacent neighbor, Robert Duffy. The driveway at issue extends from River Road and variously crosses the properties of both the applicant and Mr. Duffy as it travels a meandering route from River Road. The driveway is depicted on the map attached as Exhibit A, which map was provided to me by Andrew Leha, an attorney for the applicant, and as an exhibit to his letter to me dated February 13, 2015, addressing certain other issues regarding use of the driveway. According to this map, at times the driveway is located solely on Mr. Duffy's property for significant distances. By email dated February 20, 2015, addressed to Town Zoning Enforcement Officer Ron Evangelista from Jennifer Van Tile, the attorney for Robert Duffy, Mr. Duffy asserted that because the driveway for the proposed Country Inn is located partially on his property, the applicant is required to provide the planning board with an affidavit of owner signed by Mr. Duffy. After this issue was raised by Mr. Duffy via his attorney, Ms. Van Pyle, this issue was referred to me by the Planning Board Chair for an opinion and recommendation. Explanation Part 2, Basis for Affidavit of Owner. The basis for the Affidavit of Owner requirement originates in Section 125-66 of the Town of Rhinebeck zoning law, which sets forth the procedures for special use permit applications. Section 125-66A, entitled Application and Fee, says in part, application and fee, all special use permit applications are made to the zoning enforcement officer in writing, on forms, and in accordance with the review procedures prescribed by this section of the zoning law. That section states further in part, in order to be considered complete, a special use permit application shall be accompanied by the following. And a list of documents, item 1 through 4, is omitted. But number 5 is the certification by the applicant in writing and on forms provided by the Town of Rhinebeck that information provided is true and accurate to the best of my knowledge. In addition, the Town of Rhinebeck has a prescribed form for special use permit applications which must be completed by all applicants. Page 3 of that form contains the section entitled Required Attachments. The list of required attachments includes a document identified as authorization for applicant to act for owner if applicable. The Town of Rhinebeck has prescribed a standard form which contains both the certification of the accuracy of information in the application and the affidavit of owner. A copy of the form is attached as Exhibit B. The affidavit of owner form states that it must be filled out, signed, notarized, and provided as part of the application where the applicant is not the owner of the property which is the subject of the application. Explanation Part 3, Applicability of Affidavit of Owner requirement in this case. In this case, as proposed, the driveway that will serve as ingress and egress for guests of the proposed country inn is located on 2 parcels of land, one parcel being owned by the applicant, the other being owned by the applicant's neighbor, Robert Duffy. Because a portion of the proposed project is located on Mr. Duffy's property, and using that part of his property as part of the project, it follows that the applicant should be required to provide a completed and signed affidavit of owner from Mr. Duffy authorizing the use of his property as part of the project. Requiring the affidavit of owner from Mr. Duffy makes practical sense in a number of ways, beginning with the obvious that if a project is going to use someone's property, the applicant should be required to show they have the property owner's permission to use the property. Moreover, practical issues warranting the need for that permission can arise during the course of the Planning Board's review. For example, what if it turns out that during the course of the review, it is determined that changes need to be made to the driveway in order to make it safe for use by patrons of the new business and delivery trucks? And what if it turns out the portion of the driveway which needs to be altered is located on Mr. Duffy's property? While theoretical, this example illustrates the practical purpose in requiring the affidavit of owner from all persons whose property is occupied by a portion of the proposed project. This position is consistent with the position recently taken by this board in the case of the Red Wing special use permit application, a case which presented very similar facts. In that case, Red Wing's application for a special use permit to conduct subaqueous mining at an existing mine site proposed that ingress and egress to the mine from White Schoolhouse Road would be gained over the property of a neighbor, the Labatskys. In that case, the Planning Board asked Red Wing to produce an affidavit of owner from the Labatskys in order to deem the application complete. When Red Wing did not produce the affidavit, the Planning Board ultimately found the application was incomplete due to the lack of the affidavit. Should the applicant in this case be treated differently than the applicant in the Red Wing case, because here the applicant has a deeded right to use the shared driveway, whereas in the case of Red Wing could not demonstrate a deeded or otherwise legal right of access? No, this slight factual distinction is immaterial and does not warrant a different legal result here. In both cases, there was a dispute between the applicant and neighbor whose property was used for access as to whether the access way could be lawfully used for the proposed project. In the case of Red Wing, the Labatskys' attorney asserted that Red Wing had no right of access, and in turn, Red Wing's attorneys asserted that they did have a legal right of use based upon the historical use of the driveway. Similarly, in this case, Ms. Van Tuyl, the attorney for Robert Duffy, asserts that use of the shared residential driveway for commercial purposes will place liability upon Mr. Duffy, which is outside a reasonable interpretation of the shared driveway agreement. And he references a letter from Jennifer Van Tuyl to the Town of Rhinebeck Planning Board dated December 15, 2014, at pages 7 and 8. In contrast, Andrew Leha, the attorney for the applicant, asserts in response that Ms. Van Tuyl's assertion is contrary to fundamental principles of easement law, and he references Mr. Leha's letter to John Lyons dated February 13, 2015. As was noted in the Red Wing case, one of the ways that the affidavit of owner requirement benefits the town is that it spares the town from being the arbiter of disputes like this one. The affidavit of owner requirement assures that issues like these must be settled by the parties before the planning board begins spending its time and energy on the review of the application. As also noted in the Red Wing case, in addition to preventing completion of an entire review process where the proposed plan is premised on a disputed element, the affidavit of owner requirement also prevents the issuance of a permit where an element of the plan is disputed. In addition, the language on the affidavit of owner form makes clear the form addresses the issue of owner permission, not the applicant's right to be occupying the property, which is the subject of the application. This is demonstrated by the fact that the language on the affidavit of owner form makes clear that the form is required where the applicant is a lessee. For a lessee, there is no question that the lessee has a right to occupy the property pursuant to its lease with the property owner. Thus drives home the fact that the point of the form is to provide assurance to the planning board that the owner of the property upon which the project is proposed is aware of the project and had granted authorization to the applicant to apply for approval. Conclusion. For all the reasons above, under the facts presented here, the applicant should be required to produce, as part of the application, an affidavit of owner completed and signed by Robert Duffy, since the driveway, which will be used for the proposed country inn, is partially located on his property. I hope you find this memorandum helpful. If you have any questions, please contact me, and I will do my best to assist you. Signed, John F. Lyons, Esquire, Council of the Town of Rhinebeck Planning Board. And appended to it is an Exhibit A, which is the map he referred to. And Exhibit B is a memorandum, and the certification form is also attached. So, John has offered this suggestion that we could act in this situation as we did with Red Wing, and that would be to table the application as it is before us now, with the understanding that John believes that it is at this point incomplete. In the absence of the affidavit, we could offer to table it for a period of up to 3 months, during which time the applicant has the opportunity to further confer with her attorneys, to work with the neighbor if she so chooses, and come back to us at any time up to that 3-month period that works for her. But we could select a period, say 3 months, if that seems workable. So I would offer it up for a resolution, if someone's prepared to do that, or questions if you prefer to do that first. Comments?
I can convert that for you after your discussion.
Okay.
Effective, are we establishing that this is what we're accepting as common practice? And if we are we setting a precedent now so that anyone who comes in front of this board with a special use permit and a right-of-way has a neighbor who wants to hold them hostage? I mean, if this isn't resolved, the Duffy residents next door could hold this whole plan up indefinitely without the signature, because if we accept that as our rule, and I'm sure it'll go a step or two further legally and everything, but is that what we're saying, that we need this. I don't agree with the Red Wing comparison. This is a legal right-of-way, legal. I would like to see the right-of-way agreement myself. And I think that's very reasonable. I mean, we're basing all of this on that, and no one's shown it to us.
Let me say that the certificate of, in fact, we just spoke about this last week, the Town of Rhinebeck application certification and authorization, the top part of that, the certification of the applicant come before us, is required of every application. It's a part of our standard application process. They're attesting that they're telling us the truth. So this is circulated, as to my knowledge, to every application, every applicant that comes in, wherein there is a situation where there is a property owner whose property is part of the application. It's similar to the Pasquarelli Romeo one that we've been doing.
And the sisters'
And
place down on
the
the
sisters,
last year.
so there's been a series of them in the last year. The three parties at the property.
And I think that's absolutely mandatory. Everybody should be notified and aware, but what are the repercussions? Someone says, no, I'm not signing it, and the other landowner can't do anything?
Would it not be possible for them to put in their own driveway? I mean, if you look at the map, that driveway wanders way off their property. I don't see anything that would prevent them from putting a new driveway in.
Well, one of the things I don't want us to get into tonight is redesigning that is the applicant has the opportunity to look at the application that they
Pointing out
presented
that
to.
it doesn't seem like they're being held hostage in that regard. It might be more expensive to do that, but it's not the only recourse.
Are we capable of putting this on hold pending further legal?
But we're tabling it. John's recommendation is that we table it for a period of up to 3 months, which allows the applicant to determine her next steps. Included, and as you recall with Red Wing, we specifically said to Red Wing, meet with the Lubotsky's, try to come back to us with a solution.
Find another room.
Any other comments from?
Well, I believe this one is not setting a precedent. I think the precedent has already been set, and I think we should follow that precedent, because otherwise we're giving mixed messages, which are really confusing.
Okay.
And probably illegal in some states.
Sharon, any comments you wish to make?
The precedence you're referring to is Red Wing, where they don't have any legal agreement or deed or anything to the property. This one, there's a deed, there's a right-of-way, a legal right-of-way. It's a big difference.
I don't have the legal expertise to tell you what's right or wrong in that, but I will tell you that it's going from a private driveway to a commercial driveway, and that has a whole different set of values attached to it.
Jesse?
The change
Eric?
of use.
Are you ready? You say you have a draft
I have
resolution?
something for you.
Would you like to
Yeah,
read that?
I'm obviously taking the position of deferring to the judgment of the town attorney. Melody asked that I just quickly basically echo the sort of language that you used in the Red Wing case. And I can provide this to you, I'll provide this to you, Brennan. The planning board tables until June 2nd, 2015, or until such earlier date, the comments set forth by the planning board attorney John Lyons in his annexed memorandum of March 1, 2015 have been satisfactorily addressed. Any further consideration of the application for special use permit, Country Inn 1, submitted by Astor Courts LLC, to afford the applicant time to address Mr. Lyons' comments.
Someone willing to offer that resolution? So moved. Sharon?
Second.
Woody, second?
Yep.
Do I need to poll? I should poll the board on this one.
Yes, you pull the board.
Let me poll the board. Eric? Jesse?
Aye.
Richard? Woody?
Aye.
Sharon? I'll vote aye. That being said, obviously, we will not be conducting any public hearing this evening, and we will not be entertaining any public comment. Okay. That takes us up to 645 Edmund and Arlene Pasquarelli, 29 Delano Drive. The conduct of a public hearing on an application for subdivision plat approval for reduction of tax map parcel listed from 2.610 acres to 2.492 acres, with the other 0.11 acre to be transferred to and merged with tax map parcel listed at 15 Delano Drive, land of Joseph Romeo, all located within the rural countryside RC5 district, being an unlisted action under seeker and the subject of area variances for minimum lot area granted by the ZBA on December 17, 2014. And, okay, would you like to explain to it? There you are. Okay, great. Mr. Viteri?
Good evening. My name is Michael Viteri. I'm the licensed land surveyor who worked on this project. The project is in an RC5 zone, which both lots were undersized at that time and received a zoning variance on the December meeting. And the proposal is to transfer a piece of land from the Pasquarellis to Romeo in the amount of 5,135 square feet to accommodate a pool and pool deck, a stone retaining wall, and a proposed pavilion that is over the property line. So we aim to mitigate this problem by moving the property line to keep everything within the bounds of Romeo property.
Okay. Questions from the planning board? Okay. It's a public hearing. Are there any questions or comments from the general public?
I have a quick question. It's probably not relevant to anything, but how did a pool get built without the septic?
Shh, don't ask.
Don't ask the building department.
Definitely are wonders.
Evidently.
It's a complete mistake. It never should have happened. The permit never should
The
have.
land moved, and
Small earthquake.
Tectonic plate moves.
it doesn't appear to me that there are any comments from the public. That being the case, I need a motion to close the public.
No, you need a motion to consider the secret resolution first.
Oh, seeker motion first. Okay. So you want me to read this? As if I haven't read enough for tonight. We have a draft seeker resolution. The Town of Rhinebeck Planning Board hereby acts as follows on a proposed action involving an October 31, 2014 application by Joseph Romeo, as represented by Michael Viteri, Jr., LS, and his agent for Edmund and Arlene Pasquarelli, for subdivision plat approval for reduction of tax map parcel, 29 Delano Drive, with the other 0.118 acre to be transferred to and merged with tax map parcel 13 Delano Drive, land of Joseph Romeo, both within the rural countryside RC5 district, all is depicted on a survey map entitled Lot Line Revision, Joseph Romeo and Edmund and Arlene Pasquarelli, prepared by Mr. Viteri, dated September 9, 2014, and otherwise described in the application, and supporting documents, including a short EAF Part 1 affirmed by Mr. Viteri, and an ag data statement completed by Mr. Romeo. The proposed action, having been classified by the Planning Board as an unlisted action under seeker for coordinated environmental quality review with other involved agencies, neither is required nor has been undertaken. 1, determines upon review of the EAF Part 1 and its own completion of the annexed EAF Part 2, in consideration of both field observations and the criteria for determining significance set forth at Title 6, Part 617.7.c, NYCRR, the proposed action is described in the application and being an unlisted action will cause no potential significant adverse impact on the environment and thus issues a negative declaration, determination of non-significance, deeming an environmental impact statement to not be required and stating such will not be prepared. authorizes the chairman to so execute the short EAF and directs the planning board clerk to file the short EAF with neg deck annotation in the manner set forth within the seeker implementing regulations, Title 6, Part 617.12 NYCRR. Is that it? That's it. Could I have a motion to accept the seeker resolution? Okay. All those in favor?
Aye.
All those opposed? Abstentions.
Now another call for public comments, if any, based on the seeker resolution.
Any
No.
public comment based on the seeker resolution?
None? Now you can move.
Hearing none.
Now you can procedurally close the
And
public.
I have a motion to close the public hearing.
So moved.
Second.
Those in favor?
Aye.
Opposed? Abstentions. I think I'll just move right along to this. Are we okay to do that?
Yeah, approval resolution.
Yep. So we have a draft approval resolution.
You can dispense with the reading of the opening paragraph.
Okay, 1, reaffirms its prior acknowledgement the ZBA granted area variances to abutting owners Edmund and Arlene Pasquarelli and Joseph Romeo on December 17, 2014, in the matter of non-complying lot area, which action permits the planning board to proceed at this time with consideration of the above-cited application for subdivision plat approval and could, if approved and implemented, permit the planning board to consider certain applications under Town Code Chapter 125 zoning submitted by Mr. Romeo related to improvements he either has or proposes to undertake. 2, reaffirms its prior classification of the subdivision as a minor subdivision, lot line alteration under Town Code Chapter 101 subdivision of land, being the subject of a land development technique permitted by right within the RC5 district under Town Code Chapter 125 zoning. 3, approves the application for subdivision plat approval and authorizes the chair to stamp inside the subdivision plat for the Edmund and Arlene Pasquarelli minor subdivision lot line alteration, and the clerk to provide copies thereof to the applicant and the town assessor upon the applicant's satisfaction of each of the below conditions and/or requirements within 180 calendar days of the planning board's adoption of this resolution. Stamping of the subdivision plat as an approved realty subdivision or either as a non-jurisdictional subdivision or for filing purposes only by the Dutchess County Health Department. B, submission of subdivision plat drawings in the number and form specified within Town Code Chapter 101, including thereon all required stamp seals and certifications. C, submission of a satisfactory draft of a merger deed providing for consolidation of the 0.11 acre annexation parcel depicted on the subdivision plat immediately upon transfer with the lands of Romeo, said merger deed to be recorded in the Dutchess County Clerk's office simultaneously with the filing of the approved subdivision plat, and thus obviating what otherwise would be the creation of a separate non-complying parcel. D, payment of other outstanding fees or reimbursable amounts due the town of Rhinebeck with respect to the submission, review, and processing of this application under the Town Code Chapter 101 subdivision of land and seeker as set forth within the associated town fee schedule and related escrow agreement. In consideration of the planning board's determination that no new building lots or sites are being created deems not applicable to this application requirement for either the set-aside of parkland within the Edmund and Arlene Pasquarelli minor subdivision or payment of a cash in lieu of land recreation fund to the town of Rhinebeck for deposit in the town's recreation fund. Could I have a motion?
So be it.
Second? Okay. Poll board. Woody?
Aye.
Sharon? Aye. Eric?
Aye.
Jesse?
Aye.
Richard?
Aye.
And I'll vote aye. Thank you. Thank you. All right. Now we're up to that,
Whitman von Stoddard.
well, that being the only public hearing for tonight, we now are at the regular session of our agenda. And this is under old business. Catherine, no, I can't do it. Can I? I've got to go to 7:10?
No, you don't have to wait.
I don't have to
It's
wait?
not a public hearing yet.
Okay. Correct. Huh? I know,
Yeah,
how's
because
that
we're-
happen?
Would have been-
Catherine Whitman Architecture on behalf of Dunya von Stoddard, 362 Rhine Cliff Road, special use permit, site plan, and wetlands permit. In consideration of sketch plan conference conducted on February 2nd, 2015, and appearance before the ZBA on February 3rd, 2015, initial presentation of applications for special use permit, home occupation, site plan review and approval, and wetlands permit in the matter of proposed conversion of existing garage to art studio, construction of new garage and related site improvements on tax map parcel listed within the Rural Agriculture RA10 District, National Historic Landmarks District, and LWRA/Planning Board review for completeness and processing as may be timely under Town Code Chapter 120, Wetlands, and Chapter 125 Zoning, and seeker. Catherine?
I'll begin if you would like with a review of the project.
Yeah, and I think if you can pull the microphone to you or speak more directly into it.
I'll come over here. So the project is converting an existing garage into an art studio, and that would require adding a sink and laundry facilities, which use the existing septic system, but add pumps to have the wastewater go uphill and then use the existing system. In addition, a new garage is proposed, and that's here. This is the existing garage, the new garage, and then paths to the house that also go partially on the wetlands 100-foot buffer, as well as demolishing a shed that's on the wetlands buffer. So that's the project, and last time I was here, some items were requested. Proof that the shed was
Contributing?
non-contributing, and that's included in the package. Right here. The secondary structure, NC, for non-contributing. And then another question was what type of artist materials will be used. So included in the packet is an MSCS for the silkscreen inks. And if you look at it, it says the hazards are harmful if swallowed. It's a water-based silkscreen ink that represents no harm to the environment. So that's perfectly safe. The other elements used in the process are water and using the washing machine to launder the fabrics before and after the work is done on them. Any questions?
Planning Board? Eric?
The sheet does say prevent contamination of drains and waterways, and also it doesn't talk about what volume of this material is going to be used, how much of it is going to be flushed. And what is the potential maximum use of this material on this site?
True. I have a note in the letter that there's only a delivery once a month, and that the inks are in 16-ounce containers, but it doesn't say how many are ordered every month. But this is a very small production.
And it will remain so for the duration of this use?
Yes.
And by small, how many, what sort of numbers are we talking about? Gallons of this material a month, or?
I believe that the artist is contemplating small runs. Each one is sold individually, and it's only, it depends because she doesn't have her sales yet, but it's...
Perhaps she can get more information before. Perhaps she can get more information before.
Yeah, before the hearing.
More of a handcrafted.
Maybe,
How big is the garage?
20 by 30, I believe. It's
It
not a
really
big garage.
You really can't support that much
Probably not.
real production anyway.
well, maybe you can try to get a little more detail on that before the public hearing.
Also, it says prevent undiluted product from reaching groundwater, but it doesn't say what level of dilution would make it safe for the groundwater.
Well, perhaps that clarification will, let's just get that in the record.
It's not a form of harassment. We just want to make sure we understand what.
Maybe 10 million apples.
Exactly.
They could be small, but there could be a lot of them.
Okay.
And also, it says in this material safety data sheet that no decomposition takes place if used correctly, but it doesn't say what incorrect use might be, so maybe we can get some clarification on that.
Whoops.
I can
That,
help.
and how do we keep people from swallowing it?
Yeah, well,
I can help Catherine and the board on 3 items of information that were requested, all of which have been submitted and are satisfactory for purposes of processing. 1 is the full environmental assessment form, 2 is the coastal assessment form, and 3 is the ag data statement. All of those matters are adequately submitted. That leaves for you only the matter of the dealing with the ZBA, I think.
Ryan, do you have any questions?
For the site visit, did the clerk get to you that number for you? You had asked at the
Yes.
meeting the distance between the
Yes.
Hudson River and the
Right.
Yep.
This does not fall within that special use permit requirement. It's beyond the 1,000-foot.
Right. Thanks for getting that information, Ryan. That was helpful.
And the variance application was accepted for processing by the ZBA in early February, which has always been the standard used by this board as to whether or not it accepts an application, that any variance has to be at least in process by the ZBA.
So we're good to go with the draft procedural
You're good to go
resolution?
procedurally with the draft. The planning board has one outstanding question, besides asking for further information on the process chemicals or whatever. The question that for the board is, again, whether or not the board is going to waive or not waive the wetland delineation requirement that's set forth in the wetlands law, the field delineation.
Okay. We don't need to do that tonight,
Well,
or we do?
if you have a judgment to make about that matter, particularly if it's one that the wetland delineation needs to occur, it would be helpful, I guess, to the applicant if it were made
Yeah.
at this point in time, because otherwise it's going to be a delay down the road.
Is this for the path that goes from the building to the house?
Well, the wetlands, this is the wetlands and this stream, and the 100-foot buffer already completely surrounds the garage and the work that would happen on the driveway and the shed. So any larger delineation of the wetlands would make it the same situation, where the things we're doing are within the
And
except for the proposed garage is outside the wetlands buffer. So that, if they said the wetlands went further than it does, but that's very unlikely because this is a very well-defined pond.
The delineation that is shown on that map that Catherine just pointed out is based upon file information, essentially. The requirement of the wetlands law is that there actually be field delineation within 1 year of the date of the application, unless that requirement is waived by the planning board.
I don't see the need to do it again. If the scope, if the bulk of the work is within the, we're not going to learn anything new. If it moves 5 feet or 10 feet, it's going to change the plans or the mitigation that we're going to have to do.
I think the CAB is going to have something to say about it if it's a concern.
Do you have comments, Ryan?
At least we're out on the site.
Okay, all right.
Tell us so much.
Okay. All right, so much as we might wish to help her along with that, sounds like a field visit's necessary before you're prepared to make a comment.
Okay, so you won't deal with that issue tonight. You can deal with the procedural resolution. The
Yep.
question of the wetland delineation is still hanging out there.
Okay. Any other comments, questions before I read the procedural? The Town of Rhinebeck Planning Board hereby acts as follows in the matter of the January 12, 2015 applications by Catherine Whitman Architecture on behalf of Dunya van Stoddard for special use permit home occupation and site plan review and approval under Town Code Chapter 125 zoning and wetlands permit under Town Code Chapter 120 wetlands as amended and supplemented on February, we'll have to fill in that
Whatever
date.
date that package came in.
In the matter of the proposed conversion of an existing garage to an artist studio, construction of a new garage and associated site improvements, including SDS modifications and demolition of an existing shed, tax map parcel listed within the Rural Agriculture RA10 District, the Hudson River National Landmarks District, and the town's LWRA. All is depicted on a site plan A.0 and studio plans and elevations A.1 prepared by the applicant, and an engineering report and site plan and details for sanitary systems drawing prepared by David Ryder, P.E.P. LLC, and dated December 17, 2014, and otherwise described in the application, and supporting documents including a full EAF Part 1, affirmed by the applicant, a coastal assessment form, an agricultural data statement, and documentation of the status of the existing shed as a non-contributing structure within the landmark district. 1, upon review of the applications, classifies the proposed action as a Type 1 action under seeker in consideration of its location within the Hudson River National Landmarks District. 2, upon review, finds and accepts the applications as adequate for review by the planning board, the board's advisors, and the public. 3, schedules a combined public hearing on the applications for Monday, April 6, 2015 at
6:35, it's the first time.
6:35 p.m. and directs the clerk to undertake or otherwise cause the noticing and posting thereof in accordance with the requirements set forth within Town Code Chapter 125 zoning, Sections 125-66 and 125-77, and Town Code Chapter 120 wetlands, Section 120-9B6. Further directs the clerk to distribute the agricultural data statement in accordance with the provisions of the New York State Ag Markets Law. 5, in accordance with Section 239 of General Municipal Law, refers the applications for special use permit and site plan review and approval to the Dutchess County Department of Planning and Development for review and advisory opinion. Delegates planning board members who would like to take a trip. Eric? Eric and Sharon? To conduct a field visit to the project site and report their observations at the time of public hearing. 7, in accordance with Town Code Chapter 9, Conservation Advisory Board refers the applications to the town CAB for review and comment. 8, in accordance with Town Code Chapter 118, Waterfront Consistency Review refers the applications to the town WAC for review and comment as to consistency with town coastal policies as set forth within the town's LWRP. 9, requests further technical review of the applications by the town's planning consultant and without prejudice to information that may be presented at the public hearing or may arise on the basis of the above-cited referrals and field visit, authorizes the planning consultant to prepare the working drafts of a seeker resolution and an approval resolution for consideration by the planning board when and if timely. I have a motion? Second?
Second.
All those in favor? Aye. Opposed? Abstentions? Okay, Catherine, do you want to give your contact information to either Sharon or Eric? Might be on, do you have email on your application or anything?
You know what, I can connect them all by email.
Okay, Brennan will do that and include the CAB as well. Thank you very much. Okay, that would bring us, okay. The next thing that's up, this is under referrals, and this is the review and recommendation on proposed local law extending moratorium on implementation of green building standards, procedures, and requirements set forth at Town Code Chapter 125, Section 125-61. Art, do you want to walk us through your comments in your meeting notes, please?
My fundamental comment here is that I have not been a participant, and I'm not aware of what work may have been accomplished by a task force that was created by the town board to deal with this particular matter. On the other hand, knowing that the town board is in the position of proposing the extension of the moratorium, it's obvious that the final report and recommendations of that task force have not yet seen the light of day, or are not yet in a position to be implemented by the town board. Absent some action by the town board to extend the moratorium on the green building standards, those standards do exist in the zoning law and are to be applied by the building department, the ZEO, this board, and others. Consequently, and there really aren't any criteria for applying those standards. So consequently, I think this board is in the very simple position of repeating what the advice or the recommendation it made to the town board when the moratorium was initially proposed and I believe subsequently extended. And that is, number one, the planning board understands the necessity of a moratorium in light of the absence of any clear measures for implementation of the green building standards. Two, the board certainly wishes that this matter be resolved as soon as practicable by the town board. And three, the planning board expresses its willingness to partner with any other expert parties in whatever manner may be requested by the town board in recommending a program that would be the focus of the resolution of the question at hand, which is basically what you said the last time around.
Pretty much.
And, that could be converted to basically a consensus position.
So ridiculous.
So we wouldn't need to vote on it, just
Yeah, I think
accept it as a consensus opinion?
Establish consensus or vote, either way, it doesn't really.
Anybody want to comment on this?
Why do we have to make a recommendation at all?
Under the zoning law, this is technically,
Oh, right.
it's an amendment of the zoning law, okay?
So if we don't
Moratorium's an
respond-
amendment of the zoning law,
We
therefore
don't
it has to.
respond, we approve it.
Exactly,
Okay,
report to the board.
yeah. It's just,
We've been that route before.
you said, it's in there, it's outlined. I mean, we have all kinds of other things that we've been pushing hard. Do they really have a committee?
We don't know.
We have no choice but to say,
Do we have consensus around the,
Around the 3
comments?
points.
Woody? Are you in consensus here?
by the time they pass this, there's not going to be any big buildings going up anyway. They're all going to be done.
I hear consensus.
Yeah,
I'm too ignorant of the situation.
Consensus to
offer
issue a report to this effect to the town board.
Okay.
But I ain't against it.
All right, the ZBA referral?
Single referral, right, Brennan? Just the Whitman von Stoddard.
Business is slow, okay.
Too cold to
Do I have to read anything?
I think it's pretty straightforward. There were five minor variances that the ZEO required be addressed, and some of which dealt with proposed situations, most of which dealt with existing situations on the site.
All right,
I think you got a draft here that
I do.
basically says, ZBA, rely upon your own observations, rely upon neighbors' input, but also recognize that if there are any environmental issues here, they'll be addressed by the planning board as part of the site plan process.
okay.
I think, you're doing that with respect to the processing, et cetera.
All right, let me read this.
boilerplate form? Do we have that statement you just made?
You've got a resolution. I don't think you have to read the resolution if the board is,
Okay, that's fine.
the board is all.
Has everybody had a chance to look at that resolution? Why don't you take a quick look, and if you agree, I would entertain a motion to accept the res... Second? Second. All those in favor? Opposed? Abstentions? Okay, that will take us then, I believe,
To the signs.
to the two sign applications that are before you. I would like to start with timely signs. Someone here, this is Hudson Valley Federal Credit Union is in the process of rebranding all of their locations throughout the Hudson Valley region. This new design Okay, it's not been released. Please consider these, all right, so you have, we've got a couple of photographs here, and who's going to walk us through?
I'll walk you through the, let's start with the building sign. Building sign for Rhinebeck location for Hudson Valley Federal Credit Union.
That's the only one we're dealing with right now, just the
Okay,
building sign.
fantastic, fantastic.
And then we'll move on to the other one
All right,
after.
well,
we
Rich
finish.
is here. You're going to be here for a couple
I'll be here for a little while longer.
Okay.
Well, we're wrapping up here.
Last year, this time, we came before the board for a variance to get the sign that you see on the first page as the existing. Within the last year, the credit union has decided to change their brand, and we're proposing this new design. A little bit more contemporary logo, a few different colors, as opposed to the two previous. And this one happens to be less than the square footage that we have the variance for, just in the way that the proportions work on the building. So we're going from a 25 square foot set of letters down to a 22.6 square foot set of letters. The greens, the dark green is essentially the same. They've added a new icon that shows the Hudson River Valley, and they've gone with a two-tone, the lighter spring green and then a nice blue color. So it's pretty much a redo of the existing lettering. The lighting remains the same. The style of the letters is exactly the same. That's essentially it.
This one. Questions? Well, this is a pretty straightforward swap out.
Yeah. Actually, I like the older logo.
That's what we were saying too. We like the older one better, but
Look, you should really put this out.
You're not the only one who is kind of complaining about it, but, you know, I just make the sign.
and we didn't even, I just said, you know that's a river, right? You know that's the river.
I don't know what that was.
Well, it's about 20-some years old, and they felt it was time for a change.
some blue in there.
Because everybody pays so much attention to it.
If I might,
There's some complaints, but as you know, you can't please everyone.
Comments from Art?
No comment. Simply for the board's consideration,
People in, for God's sake.
Yeah.
Guys?
for the board's consideration, the planning board finds the revised signage package for Hudson Valley Credit Union to be consistent with town design standards and recommends the permit be issued by the, is it building department or is CEO, or ZEO?
It's ZEO.
By the ZEO.
Yeah, this goes back to Ron.
That would,
Did you get that?
the planning board finds
Revised signage.
the revised signage package for Hudson Valley Credit Union.
Federal Credit Union.
Federal Credit Union, to be consistent with town design guidelines and recommends sign permit, the related sign permit be issued by the ZEO.
I thought there was a variance for the first sign. So how could this one be?
It's not exceeding, didn't you say?
Smaller.
It's smaller.
It's smaller.
The guidelines allow for 22 square foot?
They have a variance.
They had a variance.
They have a variance.
But they're coming in less than the variance.
It's the town design guidelines.
This complies
not-
with the
not
variance
zoning
they were
standards.
given?
Yeah.
Yes.
It's less, you said.
Yeah.
Yeah. Not only does it comply, but it's actually less square footage. All right, who wants to make that motion?
So bad.
Second? Second. All those in favor?
Aye.
Opposed? Abstentions? Okay,
Thank you.
now we're
Got a minute and a half left.
talking,
Through guess it's 7:30.
all right, now you have before you a second sign application. Would you like to?
Mr. Grang, Cartier Companies, we're the property owners. As you recall, we recently converted the old brand union into a medical group and have since developed the credit union on our site. In the package that was submitted back in October, there was a narrative explaining a little bit of the history of how we got to where we are. The original approval was under a special permit that no longer existed in the code. The new code allows for 12 square foot of monument signs for each parcel. We have two parcels in this case that we crafted an easement where only one sign will be placed to serve those two parcels, and the sign is approximately 24 square feet. So it's consistent with the governor's craft. It's intended to be sited as a sister sign on the north side of the signalized intersection going into the site. And I believe the design is consistent with the town's design standards, and it complements both of the buildings on the site.
Questions? No, blends in quite well.
No, it's the right thing to do.
Okay. Any other comments, questions, concerns? You want the same motion?
Same motion? Same motion?
Just change the name.
This is their voting season.
All right. Who wants to make that motion? Woody?
I'll make it.
Second? Sharon, all those in favor?
Aye.
Opposed? Abstentions? I think that concludes the business before
Very good.
us this
Thank you
evening.
all very much.
Time for Woody.
Woody? Yes, Woody. Woody makes a motion to adjourn. Have a second?
Don't know what I'm doing, that was, I adjourned.
second.
All those in favor?
Aye.
Any opposed?
Say something. The sign-